The way things are going this morning, I would have almost believed you. You're going to throw me off. All right, Ms. Eaglin, you tested negative. It is extremely important. That's a condition of your bond that you have that drug patch. So you need to make sure and do everything you can to get it, keep it every 2 weeks, get it changed. If you don't, it's a violation of your bond condition, and you could end up back in court. You could end up in jail for violating that, okay? So it's very important. So let me get this pulled up. Ms. Eaglin, in cause number 25 DCCR 0317, you're charged with assault of a peace officer. And that is from January 14th of 2025, and that's a second-degree felony. What that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand? Speak up, please.
Yes, ma'am.
Okay, and then in cause number 25, DCCR 0318, you're charged with aggravated assault with a deadly weapon from January 14th of 2025. And that also means if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
In each of these cases, I have here on the computer a plea bargain rejection that you've signed with Mr. Rojas that shows that the district attorney's office has made offers if you wanted to enter pleas of guilty in your cases, actually in one case. So the offer is to plead guilty in the assault on a peace officer for a 7-year deferred probation with a dismissal in the aggravated assault case. You have every right to reject that offer and have your cases set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your cases set for trial?
Yes, ma'am.
And Mr. Nichols, is there any reason to believe that the offer would change? So I want to make sure you understand also that after today, I will not accept this plea agreement. Once the case goes on the trial docket, you can either plead guilty to something different, open to me, or we're going to let a jury decide, okay? All right, so I'm going to place your cases on the trial docket. Ms. Eaglin, Mr. Rojas has been appointed to represent you, and he's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him, and I can appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you? All right, so Mr. Rojas, you are released. Ms. Eaglin, if you will just have a seat right up here in the courtroom, watch for the clerk to call you up. She's going to let you know who that attorney is today so that you can contact them and they'll begin preparation for trial. All right, thank you.
Good morning, ma'am.
Good morning. You're Norberto Armenta,
Yes, ma'am.
and will your client waive the formal reading of the indictment?
So, he will, Your Honor.
Let me,
And Judge, if we may proceed on what I have numbered as 1, 2, and 3. My position on that is it's the first paragraph, the second paragraph, which is a jurisdictional paragraph to get us to the DWI third, and then a regular felony prior.
Okay,
I see.
so technically two
Technically 2. I just
counts with
didn't know
the
if-
second
how
paragraph.
it kind of looks like a paragraph on its own, but it's just jurisdiction.
Okay, and so in cause number 25, DCCR 0168, you're charged with the third-degree felony offense of driving while intoxicated, third or more. That's from April 25th of 2024. The indictment alleges you were previously convicted of driving while intoxicated, February 5th of 1998 in Harris County, Texas, February 6th of 2008 in Harris County, Texas, and then again September 8th of 2023 in Harris County, Texas. And then the second count in this indictment alleges that you were previously convicted of possession of a controlled substance, second-degree felony, June 24th of 2004. And how do you plead to that charge?
Guilty.
And are all those prior convictions that I read out for DWI as well as the possession of a controlled substance true?
Yes, ma'am.
Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
I have here on the computer tablet some documents that have your signature on them. that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 12 years in prison. And I want to make sure you understand what that means is you're leaving your punishment up to me. And as long as I don't give you more than 12 years in prison, then you can't appeal. If I can give you 12, I can give you less. It'll depend on the information that's brought to me at a sentencing hearing.
Yes, ma'am.
You have an absolute right to have a jury come in and determine 2 things. The first is to determine if you're guilty or not, and then you could leave your punishment up to that jury. If we go forward this way, you're waiving that, and is that what you want to do?
Yes, ma'am.
It shows also as part of this agreement that the state will dismiss cause number 25, DCCR 0169, and it will run concurrently with any other felonies that you are currently serving time on. Is that your understanding?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Without objection.
It's admitted. Is there any evidence that Mr. Armenta is not competent?
None that I'm aware of, no.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That will give me more information about you, your case, and then we'll come back later for sentencing, right? You can go back with the bailiff.
Your Honor, just to be clear on the paperwork, it reflects we're not requesting probation, we're requesting a five years.
I saw that, yes, sir, thank you. All right, you can go back with the bailiff.
I'll be out to see.
All right, so you are Daryl Spencer?
Yes, ma'am.
And Mr. Spencer has 4 cases, 24 DCCR 1863, charged with possession of marijuana, 25 DCCR 1149, charged with evading arrest or detention with the use of a vehicle, 25 DCCR 1150, charged with unlawful possession of a firearm by a felon, and then 24 DCCR 0841, also charged with evading arrest or detention with the use of a vehicle. And the state has filed motions in those 2 newer cases, cause numbers 25 DCCR 1149 and 1150, to raise the bond in those, or increase the bond. It looks like the current bond in each of those cases is $15,000. The bonds on those 2 previous cases, one was $7,500 and one was $25,000. And Ms. Malfino, you may proceed.
Judge, based on the fact that Mr. Spencer was out on bond, bless you, and then committed at least two additional felony offenses, we would ask, just based on the totality of the circumstances, the nature of the offenses themselves, that the court raise all of those bonds and place him back in custody. And I will provide discovery to Mr. Kimler on the 2 new cases. He indicates today that he's going to be hired on those, but
I have you on all of them, right?
Yeah, I'm on all of them.
Okay, I'll make sure.
If everyone will give me just a minute, I am going to take judicial notice of the court's files and all of the cases, which include the probable cause affidavit in those 2, well, all of them. Give me just a second to.
Just to be clear, the offense dates on the 2 new offenses are after the other 2 offenses, is that right?
Yeah, so the offense dates on the 2, we've got the possession of marijuana offense date of February 15th of 2024, and the evading arrest or detention from March 2nd of 2024. And then we've got 2 new cases, one from June 14th of 2025, the evading arrest or detention with the use of a vehicle, and then June 15th, the unlawful possession of a firearm by a felon of this year. So give me just a second to review all of this, and then I'll let you.
You make sure you sign it.
Sorry, I should have had these done already.
Maybe it's.
Got one more I'm coming, I think. Oh, wait, that's what I'm see. 08. All right, so let's see. On the two older cases, it looks like bond was made May 24th of 2024. So he was definitely out on bond on those when the two new. I should have one more.
Additionally, Judge, he has been before this court before in 2017, as well as next door in the
So we've got, here's the,
We're gonna just go with the Class A amount. When this piles up heavy, yeah, it's gonna drag in. So it's not be less than 750. The full amount, look less than 750. Yeah, that should get us to what, Class A or B?
Yes, that's enough.
Let's do A, that's what we'll do.
Thanks, honey. Just close it.
all right, so the unlawful possession of a firearm by felon and that evading, same offense, or date, pretty much same. And then okay, I should have another one. I should have one. Is there not anything else I printed?
Two of them are the same.
I know. I should have three. These two are the same, but I should have this one and another one. I thought
That's the three printed.
okay, hold on.
Yeah.
All right.
I think I filed them in both cases.
You did. I'm just trying to find the
The same
PCs
PC.
from the, I'm trying to look at the underlying PCs as well. So give me just a second to pull up the, which one is, what am I trying to
Well, it'd be
find?
the same, probably the same PC for
Two
each
same.
case.
Evading
Two printed.
0841. I didn't just print this one?
And two of them look just the same, but there's still one in it. And that's all.
Okay, maybe that's it.
This stuff's just better.
Why did it do two? What's happening? Okay.
I'll sign it out. Is this a lot?
So you said he's previously been in other courts. What other, do you have convictions?
I do, Judge, I do have a conviction in this court from May of 2017, 9 months in state jail for engaging in organized criminal activity. Also, it appears that in 2017, he was also in drug court for third-degree possession. It looks like he received probation on that case. There was a knock on that, so I don't want to misrepresent that. He did get 3 years TDC on that, Judge, on revocation, and then in CDC back in 2023, he was given a lesser included Class A deadly conduct where he served 1 year in jail.
Mr. Kimler?
Well, yeah, I'm not prepared to litigate the merits of the two new cases without compromising defense. I suppose the court will have to stand on the PCs. I know that he's employed, is that correct?
He's what's on the report, yes, sir.
Longshoreman, and is endeavoring to maintain a law-abiding lifestyle. I believe he could pass a drug test in lieu of an increased bond if the court is inclined to take some sort of remedial measures. Regarding Mr. Spencer's conduct while on bond for the previous two cases, I would suggest a GPS device in lieu of increased bond.
I don't see how a GPS is going to help when you're out on bond, you've got 2 felony convictions, a state jail and a TDC conviction. You're out on bond for a felony possession of marijuana and an evading arrest, and there's an additional arrest for an evading and an unlawful possession of a firearm by a felon. I'm going to, based on the criminal history, based on the nature of the underlying offenses, and all of the factors in 17.15, I am going to grant the state's motion to increase bond in cause numbers 251149 and 251150. I'm going to raise the bond in each of those cases to $100,000. Condition of those bonds, if made, are that Mr. Spencer not be allowed to drive a vehicle, period, on bond, and that he wear a, I'm not worried about that necessarily. Obviously can't have a firearm, but no driving whatsoever. All right, you can go back with the bailiff, and I'll reset the case for an announcement for the cases.
The only thing that I would add, Judge, is that we now have an agreed restitution figure for
That's
the court.
my question.
Yes.
What is it?
$60,000.
Okay. All right, ma'am, you are Sydney Lewis. And Ms. Lewis was previously here in cause number 24, DCCR 1905, entered a plea of guilty to the third-degree felony offense of theft of property. I've received the pre-sentence report. Have you both had an opportunity to review that report?
The defense has, Your Honor, we have no objections.
Yes, Judge.
And Mr. Smith, any objections or corrections?
No, Judge.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You are ordered to follow all of the rules and conditions of probation, and that includes paying back the restitution of $60,000. If you do all of that, this is an excellent opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, you'll never have a felony conviction. The case will be dismissed at the end. The other side of that, though, is if you violate any condition of probation, you could be brought back into court, you could be found guilty of the offense, and you could go to prison for anywhere between 2 years and up to 10 years. Do you understand? Also, $60,000 is a lot of money to pay back. And sometimes what people will do is they think, I'm going to wait and I'll pay a little bit next year when I get my tax return, and maybe I'll sell this in a year or two, and I've got 10 years, so I've got plenty of time. You will be surprised how quickly that time will pass. And at the end of the probation, you could have done every other thing correctly. And if you don't pay that restitution, and I make a finding that you could have, you can still go to prison for up to 10 years at the end and your probation be revoked. So I want you to pay something on the restitution every single month, because even if it's not a huge amount, it will add up over that time frame. Does that make sense? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. When probation's ready to go over your paperwork, she'll call you up to her desk, all right? Good luck to you, ma'am. Thank you.
Thank you, Judge.
And then you've got a David Melanson, Mr. Crenshaw.
Yes, sir.
Good morning, sir. Are you Michael Barelick?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
will, Your Honor.
And it's just the lesser Class A theft, correct?
Yes.
Mr. Barelick, in cause number 25, DCCR 0003, the state has elected to proceed on the lesser included offense of a Class A misdemeanor theft of property from June 24th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they charged you with?
Yes, Your Honor.
I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
And are you a U.S. citizen?
Yes, Your Honor.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Barelick is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the Class A misdemeanor theft of property. Sentence you in accordance with your agreement to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir.
Thank you very much. Thank you, sir.
Good morning. Are you Kevin Calise? And Mr. Calise, this is your initial appearance in cause number 24, DCCR 1948. You're charged with theft of property from July 1st of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Did you get someone hired already?
I've talked to somebody, but I'm willing to get somebody hired.
So what I'll do is reset your case about 30 days to give you some time to try to hire somebody.
Okay.
If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of who you've talked to so I know you're trying, and then we'll discuss your options.
Okay.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice.
The only thing that I would add, Judge, is that we now have an agreed restitution figure for
That's
the court.
my question.
Yes,
What is it?
$60,000.
Okay. All right, ma'am, you are Sydney Lewis. And Ms. Lewis was previously here in cause number 24, DCCR 1905, entered a plea of guilty to the third-degree felony offense of theft of property. I've received the pre-sentence report. Have you both had an opportunity to review that report?
The defense says, Your Honor, we have no objections. Yes, Judge.
And Mr. Smith, any objections or corrections?
No.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You are ordered to follow all of the rules and conditions of probation, and that includes paying back the restitution of $60,000. If you do all of that, this is an excellent opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, you'll never have a felony conviction. The case will be dismissed at the end. The other side of that, though, is if you violate any condition of probation, you could be brought back into court, you could be found guilty of the offense, and you could go to prison for anywhere between 2 years and up to 10 years. Do you understand? Also, $60,000 is a lot of money to pay back. And sometimes what people will do is they think, I'm going to wait and I'll pay a little bit next year when I get my tax return, and maybe I'll sell this in a year or two. And I've got 10 years, so I've got plenty of time. You will be surprised how quickly that time will pass. And at the end of the probation, you could have done every other thing correctly. And if you don't pay that restitution, and I make a finding that you could have, you can still go to prison for up to 10 years at the end and your probation be revoked. So I want you to pay something on the restitution every single month, because even if it's not a huge amount, it will add up over that time frame. Does that make sense? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. When probation's ready to go over your paperwork, she'll call you up to her desk, all right? Good luck to you, ma'am. Thank you.
Thank you, Judge.
And then you've got a David Melanson, Mr. Crenshaw.
Yes, sir.
Good morning. You are Mark Hebert.
Yes, ma'am.
And Mr. Hebert was previously in court, entered a plea of guilty to driving while intoxicated, third or more. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
Your Honor.
I have none.
Are there any additions or corrections?
None more, Judge.
Not from the state, Judge, sorry.
Okay, that's right. And so, Mr. Hebert, I am going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement to a term of 5 years in prison, but I'm going to probate that. You'll be on probation for 5 years.
Thank you, Your Honor.
You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. In addition, you are ordered to serve your 10 days upfront time in the Jefferson County Jail. Are you working?
Just being temporary, yes, ma'am.
Okay, so you could either go do your 10 days if you're ready to go do those today. I will allow you to do weekends if you're working.
Okay, I thought I already did 10 days.
No,
It doesn't count.
We had
Yeah.
talked before about doing it on weekends. I'm not sure if would you rather do it on weekends?
Yes, sir.
Okay, so what I am going to do is order that you serve those 10 days on weekends, starting this weekend, September the 19th. So you will be ordered to turn yourself in every Friday at 6 o'clock to the Jefferson County Jail. You'll stay the weekend, they'll let you out, and you'll keep doing that each weekend until you serve that 10 days.
Okay.
It's very important that you're on time to the jail and that you also not show up obviously under the influence of anything, because that would obviously be a violation of your probation. So if you do everything you're supposed to while you are on this probation, this is an excellent opportunity because you will be able to serve that 5-year sentence while you're out on probation. The other side of that, however, is if you violate any condition of probation, you can be brought back into court and you'll be facing that 5-year sentence that you've already agreed to. Do you understand?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal.
Judge, would the court, excuse me, consider either JCDI or drug catch? I don't know if the interlock
It's
is
probably,
necessarily
can I see that
appropriate. It was
back? I'm
in the-
sorry.
It
What's
was,
this?
No.
Oh,
it may already be
sorry.
in the orders. My concern is it being a drug issue versus alcohol.
Yes, JCDI is in there. Okay, so part of the conditions of your probation will be that you enter and successfully complete the JCDI program. And so that is an outpatient treatment program. It is very important that you go to every meeting, you not test positive for anything. I think in addition, I don't know that I'm required to, the interlock is required by law unless I make a good finding otherwise. If,
I don't think it would hurt anything. I just wanted to bring that to the court's attention.
no, but I'm thinking I'd much rather probably a drug patch. That's probably going to be part of JCDI anyway, but it's going to be part of the probation for
If
sure.
there's any medication you're on prescribed by a doctor, you need to make sure you
Give that to
talk to
probation.
probation about that. Because he has the medication.
Are you driving?
Yes, ma'am.
Do you currently have the auto ignition interlock device on your vehicle? Okay, talk to probation, that'll probably remain at least for some amount of time. By law, that is required that you have that on your vehicle, okay? All right, you can have not yet. I also handed you a admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right? If you'll just have a seat here in the courtroom, probation will call you up when she's ready to go over your paperwork. And then you've got a Jasmine Dempsey.
This one's cool.